Hello, everyone. My name is Ruth Moisa. I am a real estate broker, mortgage broker, and an insurance broker. And I focus all three into helping women plan for their retirement. I've invited a great guest here, Ron Baranski. He's an estate planning attorney. And this is so important that I wanted to make sure that you have the right information and you have a plan for when you move on, or even when you're alive. So, Ron, take it away.
Well, as Ruth said, my name's Ron Baranski, and I've been licensed 20 years in the state of Texas. I have focused the last 10 years on estate planning specifically. And when Ruth and I talked about doing this event, we kind of thought, what are a couple of key documents that every person should have? Basically, every adult person over 18 years of age, what documents should you have? And it comes down to this. The first one is a durable power of attorney, and with a durable power of attorney, you name an agent, and that might be a family member or a trusted friend, and that agent can step into your shoes and take over and handle your financial affairs if you become incapacitated. And none of us want to think of that happening, but uh, perhaps tomorrow you drive down the road, have a car accident, and hopefully it's short lived. It could be a few weeks, a month, or a year. And what happens there to your affairs? And that's why you need the document. Because with that document, your agent can go into banks, deal with your financial accounts, pay your bills. They can deal with the IRS. There's a variety of folks they can deal with, and it's just something you need to avoid. The only other alternative is for someone to go in to court and have a guardianship proceeding take place and be named your guardian, and that's a much more expensive proposition
So,
than.
so let me get this right, Ron. So, if somebody gets into an accident and they can't make decisions for themselves, in order for someone, even the spouse, to be able to take them off life support or whatever, they need a medical power of attorney, correct?
That's where I was headed next, Ruth. And so the durable power of attorney, I usually refer to as the financial document, financial power. Uh, the second document everybody needs is a medical power of attorney. And just like on the durable power of attorney, it's going to name an agent that can make healthcare decisions on your behalf. Just as important, I looked at your forms in California, and you marry the healthcare directive into the medical power of attorney. Well, the healthcare directive portion of that is what I jokingly refer to as the pull the plug document. But it's the
Okay.
document where you put down in writing whether or not you wish to be kept alive using artificial means, even though you're expected to die within 6 months using all available means. And
Right.
for a lot of my clients, they don't want to be kept alive when they're faced with dying in the next few months anyway. Uh, but in all fairness, that's your choice, and that's where you can put it in writing. And you can also go the other way. You can say, I want all available means used to keep me alive. The key thing is it needs to be in writing. And just as important, communicate your wishes to your agent and your close family members so that when you go to the hospital and this event occurs, no one has to say, well, what did mom want to do? I don't know if I agree with that. Well, she told you, and it's in writing.
Right.
So we have no disagreement there.
And this
And
is in all 50 states?
all 50 states have some version of that. In Texas, we have a medical power of attorney and then a separate document called a healthcare directive. But as I looked at California, it's married together, combined. Uh,
Okay.
so every state is going to have some version. So we'll say that you either need two documents or three
Okay.
to cover. But
Depending on.
generally, if you came to my office or another attorney's office and you said, first things first, I need to get a durable power of attorney and a medical power of attorney, they're going to send you down the path for these 2 to 3 documents.
So this is the first. These are the first items. So what else goes into the estate planning?
Okay, and that's a good question, because after we cover those, what does everyone need? Then we can kind of have a general discussion about estate planning in general. Everybody's heard, the last will and testament, or the will. That's everybody kind of knows what a will is, but there's some misconceptions about things, and one of them is that we'll say Dad went down to the attorney's office. He met with the attorney. He signed his last will and testament. They had witnesses. They had a notary. Dad comes home and says, I've taken care of my affairs. Should I die, my kids can open the will and split things up as they want and go on their merry way. That's not the case, because your will has no legal effect until a probate judge has deemed it to meet the formalities of the state where you die. And so then you're coming into something called probate. And, that's an evil word sometimes for people. And it can be tremendously bad or it can be less bad. I say it kind
Depending
of
on
like
the state.
I say it kind of like this. It varies from state to state. Texas, we look at about a $3,000 to $5,000 cost. Arkansas, on the other hand, 2.5% of the estate. So a $500,000 house sitting in the estate, that's 15 grand. That's going to go to an attorney and a court. Uh, Based on what you told me, Ruth, in doing probate work with real estate, you can range anywhere from 15 to 30,000 in California.
Correct.
But not only do you have those expenses, but you also have uh, the experience of, during the most traumatic time in your family's life,
Correct.
having to deal with attorneys and probate judges and a bunch of issues you don't want to mess with, and wait 6 months, a year, 18 months before anything is distributed. And
Correct.
so it can be a real hang up for folks.
So what's the best way to handle this? Where do you come in? How do you make things easier for someone?
Well, there's another tool, I would say, that estate planners use. And when you go to an estate planning attorney, that's part of their job, is to figure out what tool fits best with your needs. Uh, but the revocable living trust is a great solution for that. And to explain a trust better, I like the analogy of when you was a little kid, you probably had a little red wagon with a handle on it.
I did.
You put your toys in it and you carried it around, and those were your toys, and you took them where you wanted them. Uh,
Yes.
think of a trust like that little red wagon, and you putting your toys in there, but you still control it because you got the handle.
Right.
And just like you would in a revocable living trust, you control what goes in it or what comes out of it and where it goes. You're in control for as long as you're alive and competent. But if you become incapacitated, then you've named a successor trustee, somebody that you trust, and they can walk over, pick the handle up, and take off with it. And then they can handle those items.
So then if I'm still alive but incapacitated, my successor trustee can take over?
They absolutely can. And
So
if
I don't have to be dead.
you don't have to be dead, it's a good tool. It's actually a little more effective tool than the durable power of attorney. because we've
Mm.
already, when we set up the trust, we fund it. And that means we put the toys into the wagon. We put uh, joint investment accounts, savings accounts, maybe retirement or insurance products. Um, we put these things into the wagon and just kind of picture it that everything in the wagon avoids probate. Uh, but then the other question is, what if you pass away? Well, if you pass away, same thing happens. And I don't want to be too frank here, but uh, the trust doesn't care. The successor trustee uh, picks the handle up and continues on with it. And then the trust directs the trustee, whoever that is at the time, to follow what's written in the trust as to distributing the property upon my death. And that may bring about an immediate transfer, or it may be something that's transferred over a term of years. Many times people will give stuff to their kids, one third at age 30, one third at age 35, and maybe the last third at age 45.
So the
So
successor trustee then, um, the trust doesn't necessarily close down.
it
It,
doesn't
it can
have to.
it
It
can
can,
continue if there's like minor or maybe a special needs child that needs.
absolutely.
Okay.
There's and I won't go into the weeds too far on that, but for special needs, there's a supplemental needs trust that is a real good tool specifically for uh, disabled children, disabled adult children,
Uh huh.
uh, to help their daily life be improved without shortcutting them on the benefits they would receive from the government. Uh,
Okay.
so we've got the revocable living trust kind of covered, and but I do want to say that uh, in some cases, especially in Texas where we're a little more probate friendly,
Mm-hmm.
there are times when I have clients where a will does fit their needs and it accomplishes their goals. That's the key thing, though, is the attorney needs to seek out and decide what are the client's goals. How do I get there? And for some, a will and the associated documents accomplish that. But for others, they'll need some kind of trust document. And as you mentioned, there's a whole nother step where you can create a supplemental needs trust just on its own if you have a disabled child, and it has a little different rules to it. So I won't get into that too far.
Right. Right.
Um,
So what happens
uh,
if somebody doesn't, or they might have children, but they don't have any communication with them? So you're a woman with really no family. What do you do then?
well, one challenge, and I've dealt with that. That's a challenge, but you can name. There are some attorneys that will take the place as a trustee.
Fiduciary.
They have a fiduciary duty in that capacity. That's one of the higher priced kind of people that you would put in that position. Many states also provide for some statewide uh, programs that provide for people that can act as a fiduciary for people in that same situation.
Okay.
But many times I try and look for that lady. A lot of times will have maybe a trusted girlfriend or
Okay.
somebody like that she would name that she trusts with. She's known a decade and she trusts her. Uh,
Okay.
and then you may fall back on a corporate trustee as well. You could have a bank or another institution step in as maybe the fallback as a
Oh, I've seen that. Yeah.
corporate trustee.
Okay. Okay.
And I did want to say that we're probably talking to people throughout the country,
We
and
are.
I'm licensed in Texas, so I can only represent people in Texas. But I am in a group that has, I believe, about 3,000 estate planning attorneys around the country. So if people want to reach out to me, direct message with a city and state, the closest city and the state they're in, I was going to say I can find them somebody in about 15 minutes, but 24 hours, I could have at least one name, but I'd probably give them 2 to 3 names of
That
people
you can trust.
that I trust that they can
Okay.
work with.
All right. Well, I mean, ladies, if you're in my group, you can put a comment in there, hashtag estate attorney, and I'll reach out to you, and then we can get in contact with Ron. And if you have any questions, or if you're watching this as a replay later on, feel free to reach out to either one of us. Ron is in the group, so you can send questions to him or myself, and we can answer any questions that you might have.
Absolutely. I really appreciate you inviting me to join your group today, and I hope this was educational and informative to your members.
It was very informative. Thank you so much, Ron.
You bet. Have a great evening or afternoon, Ruth, and we'll talk soon.
All right, you too.
All
Take
right.
care. Bye bye.
Bye.